website, as you can see here, VNC. Yeah, VNC stands for Victor Garuya Consultancy. It also provides other services like legal writing, blogs, and it can also host you if you have a publication you want to make. So let us delve into the history of death sentence in Kenya. But people thought that Francis Muruatetu is the one that was brought to the limelight even before the cases emerged. But that is a misconception, because if you can see here what I've said, let us now understand the history. The constitutionality of the mandatory nature of death sentence had engaged many courts previously in a jurisdiction debate. It had also emerged that the High Court and the Court of Appeal, in many cases in the country, had held a divergent opinion concerning the matter. While the law at that time recognized the death penalty as a mandatory punishment in respect to offences aforementioned, e.g. the capital sentences. And the last execution, is important to note, was taken place in 1986. The man was Zakaria. So I want to take you back and let us analyze the first case that came into the limelight even before Muruatetu. It started with the Mutiso case under the repealed constitution, in which the Court of Appeal, in that case, opined that it denied an accused person right to fair trial in breach of section 77 of the repealed constitution. So, as early as that time, someone brought an appeal against the Republic. The person was known as Mutiso. And Mutiso, what he was opining is that the mandatory death sentence penalty was breaching his constitutional right. Let me tell you what happens when one is granted a death sentence in Kenya. First of all, if you check in how community maximum prison is structured, there was a part that where prisoners of life imprisonment and those serving death sentence were separated from each other, segregated from each other. The death sentence punishment was so harsh to an extent that you are only laid in a room with darkness, and your movement is strictly contained. And there was some allegations that even there was a pole in that room and you are unchained on that pole. You can imagine how the circumstances were. So when one is convicted in a death penalty in Kenya, that means you have no hope unless the president gives you what you call a power of mercy. In another video, I'll come directly and tell you what it entails by a presidential pardon procedure. A lot of people don't know how to do a presidential pardon in a letter. And the letter is so vital because you only write the letter once. And if the letter is rejected, you only have one final chance to repetition the president to grant you the power of mercy. That video will also entail what do the president advisory committee on power of mercy look at before advising the president to release that convict. For instance, there is a man who had cancer and is about to die in the prison. Should that man be granted the power of mercy in order to die, to breathe his last with his family? As I told you earlier, this channel will bring out the emotions behind cases. We will also tackle the hardest cases in Kenya and handle each crime independently on its own. I want to take you back to the history. I want to connect you to laws of Kenya. People don't understand. I want to advance our jurisprudence of law. Now, back to the discussion. The Mutiso case, you have heard that the Court of Appeal had opined that Section 77 of the repealed Constitution, in real sense, in other words, they found out that it was an injustice to Mutiso. And the holding of the court was, on our assessment of the issue at hand and the material placed before us, we are persuaded and now so hold that Section 204 of the Penal Code, which provides for mandatory death sentence, is antithetical to the constitutional provisions on protection against inhuman or degrading punishment or treatment and fair trial. If you want to now go and make notes over the same, I'll provide this link where you will be clicking and it will be taking you direct to this page for you to follow up. This is just a brief summary. I want you to understand why the Francis Muruatetu case became a landmark case and why many courts have misinterpreted it to an extent. The Supreme Court in 2015 had to create guidelines on how the case holding will be applied and mitigating factors. Now, after the Mutiso case holding, there is a Mwaura case. I want you to note that those two cases come even before the Francis Muruatetu case. And note that remained the position. Which position? The position that I'm referring to was that Section 204 of the Penal Code still maintained a mandatory death sentence. And Mwaura case now, in which the Court of Appeal changed its holding by the use of word shall, Section 204 of the Penal Code was couched in mandatory terms, leaving the court with no discretion but to impose the death penalty. Let me tell you something. When the Acts of Parliament has used the word shall means must. So that means that when someone is being convicted of a capital offense, the judge must or shall have only one choice of handing down a death penalty over the convict. There was no listening to the emotion of this person. There was no mitigating factors. Sorry. So there is another video that I will do on ADR in Kenya. ADR is Alternative Dispute Resolution in Kenya. ADR provides us a platform where parties can solve disputes without engaging the courts. I have written an abstract over the same, and I have found out that ADR incorporates emotions of those parties. And the end result of ADR is to connect these people together again. The courts are a battlefield. People want to exchange words. People want to use their money. So you find that in that ADR, you'll find that if the ADR will be repugnant to, let's say, the Constitution, then it won't apply. The Constitution becomes the binding factor. So that is the Mwaura case. And the Court of Appeal had agreed that the word shall was simply giving the court no discretion but to impose the death penalty. Now let us go to the start of the problematic interpretation. As you have heard on over, the overarching position flowing from the Mwaura case and the Mutiso case is that the coaching of Section 204 of the Penal Code with mandatory word shall gives trial judges no option or discretion to mete out any other sentence save the death penalty. Some Kenyan courts have even observed that mitigating factors in such cases were at best superfluous in terms of the sentence provided. It therefore serves no purpose for the trial judges to hear mitigating factors from convicts in such cases. There is another different video I will also do on what are these mitigating factors. We will analyze every mitigating factor one by one. How are the mitigating factors helping a convict to receive a lesser sentence rather than the death penalty, rather than the life imprisonment? Who are these people that have been helped by these mitigating factors, e.g. provocation? How is provocation admitted? And to what extent will a provocation not be allowed? Now, let us go to the pre-facts of the Mwaura case. The petitioners and others were arraigned before the High Court, before the judge, Justice Msanga, for the offense of murder. That is not in dispute. Upon their conviction, they were sentenced to death as described by Section 204 of the Penal Code. The appeal to the Court of Appeal against both that conviction and sentence was dismissed. Aggrieved by that decision, they filed two separate appeals in the Supreme Court, which have since been consolidated together with now the Francis Muruatetu. They also describe their incarceration for 17 years in segregated death row as agonizing. Now, what is the issue before the court in Francis Muruatetu case? I've told you that Francis Muruatetu case has been consolidated together. It's like Francis Muruatetu is representing other convicts in Kenya served under the mercy of the president. Issue before the court. The main core issue in the present appeal was the compatibility of the mandatory death penalty with the Constitution, and not the constitutionality of the death penalty itself. A lot of law students have been confused on that definition. Listen, the main issue present in the appeal is the compatibility of the mandatory death penalty with the Constitution. The Constitution guarantees one right to life, and it's the role of the state to protect that right to life. At the same time, the mandatory death penalty is an infringement on the right to life of a convict, because not all people commit a crime intentionally. Not all people. There was some circumstances underlying the provision. There were some circumstances that influenced the decision of this person. How will the court be mandated to only issue a death penalty even if the person never willed to kill another man? Now, that is the overall position. Now, where the people confuse is that they say that death penalty is unconstitutional. That is not the case, because under the guidelines that were given by the Supreme Court, it was determined that death penalty is still applicable, and it was also given in the now recent decision on Willie Kimani case. We find that there are some circumstances where, let's say, like if a person was murdered and maybe he stabbed someone with a knife, and he stabbed this man not once but maybe 27 times. So you can see how this person is so inhumane in committing that offense. Now, in brief, issue number one before the court was whether the mandatory nature of death penalty provided for in the Penal Code under Section 204 was unconstitutional. B, whether the indeterminate life sentence should be declared unconstitutional, and whether this court can or should define the parameters of a life sentence, and what remedies, if any, accrue to the petitioners. Now, do you understand issue B, whether the indeterminate life sentence should be declared unconstitutional? It was the ruling of the court, that the Supreme Court, that said that this issue will not be addressed in the court because it had not emerged from the subordinate courts, and therefore it was done away with it. But what did Francis Muruatetu and others want before this issue, if it was to be allowed? They wanted that the life imprisonment have an year attached to it. Let's say a judge wants to give you a life imprisonment under manslaughter. The maximum sentence is life imprisonment, and we know that judges have a discretion to either grant you maybe 20 years or lesser years. But they wanted, when a judge maybe says that you are convicted of a life imprisonment, the judge says for 70 years, etc., 80 years. Because if you listen to some documentaries, e.g. that issued by the Jera Initiative by Noro, it addresses on the regrets of convicts in jail. If you listen also to Denison Sarigo on interviews with the prisoners, you will hear something behind the voices of these convicts. All of them are remorseful, and they all wish to get out of that door. And what will happen if the application to the president for power of mercy is rejected? You see, at least the courts of Kenya should attach a near to this life imprisonment. It will also aid in the mental preparation of this convict. And what are the parameters of a life sentence? The judges answered that issue by providing the mitigating factors that will now enable the courts to grant a life sentence and a death penalty in Kenya. But before this court of appeal, Francis Muruatetu and others had produced a rule applicable. The rule applicable was found in the case of Patrick Reyes versus the Queen of 202, an appeal case. Like in this appeal, the Privy Council was at that time. Now the Privy Council has been now, what can I say it? The Privy Council has been substituted to what now we call the House of Lords. The House of Lords at that time was called upon to consider the mandatory death sentence imposed on appellant upon his conviction for the offense of murder. Now the Supreme Court now in that UK regime was called now to consider whether the mandatory death sentence imposed on the appellant was constitutional. It unanimously quashed Reyes' death sentence. In reaching that conclusion, the Privy Council cited with approval the 1989 House of Lords Select Committee's report on murder and life imprisonment, which had concluded that murders differ so greatly from each other, and as such it is wrong to prescribe the same punishment for all murders, and the observation of the Inter-American Commission that the mandatory imposition of the death sentence is unconstitutional, and as that it disregarded an offender's personal circumstances, thus robbing him of personal dignity. In short, the court was so convinced that not all cases of murders are the same, and therefore subjecting a convict to only the death sentence was robbing the convict personal dignity. And they also relied in a landmark Kenyan case to further their support of the argument. And they cited the Court of Appeal decision in Godfrey Ngodo Mutiso versus Republic. It is a 208 case in which the Court of Appeal appreciated that a uniform sentence deprives the courts from considering mitigating circumstances and fails to appreciate that sometimes there may be unequal participation in a crime which would result to different charges and sentences on the accused persons. You have heard the term mitigating circumstances, and now this laid the landmark to the ruling that will be given by the court. But I want you to listen to what the Attorney General had to say in the Francis Muruatetu case. The Attorney General, in his written submission dated 25th March of 2016, and submitted that under Section 27(1) of the repealed Constitution, had said that mandatory death sentence was at the time imposed on the petitioners expressly legal and constitutional because the mandatory death sentence was in the Constitution. He, however, asserted that under the current Constitution, the 2010 Constitution, it was unconstitutional not because it is cruel, inhumane, or degrading, but because it compromised the right to a fair trial. You have the right to be presumed innocent until proven guilty. That being the case, and since the current Constitution has no retrospective application, our Constitution is prospective, it applies in the future. The Attorney General urged that the petitioners were not entitled to challenge the constitutionality of the mandatory death sentence. They should not say that mandatory death sentence is not constitutional. However, at any rate, he submitted that the sentence having been commuted to life imprisonment by the President, it was odious to challenge its legality. He therefore dismissed the petitioner's prayer that the matter be referred back to the High Court for resentencing. Now, let us have a look to what Section 204 of the Code directly provides. In the light of the above positions, it falls upon this court to bring clarity and make a determination whether the mandatory nature of death penalty under Section 204 of the Penal Code meets the constitutional standard. The section, I want you to listen, the section categorically describes that any person convicted of murder shall be sentenced to death. There is no mention of mitigating factors, and that led now to a United Nations Commission on Human Rights say the United Nations Commission had written a report and said that the abolition of death sentence as a mandatory sentence was recognized as in the Human Rights Resolution, and the title was The Question of the Death Penalty. And the resolution urges all states that still maintain the death penalty to ensure also the notion of most serious crimes does not go beyond intentional crimes with legal or extremely grave consequence, and that the death penalty is not imposed for non-violent acts such as financial crimes, religious practice, or expression of conscience and sexual relations between consenting adults, nor as a mandatory sentence. By this United Nations Commission, it will also give birth to several videos that I will also do. I will also tell you financial crimes, white collar crimes, how are they committed. No other channel will tell you about white collar crimes in Kenya. What does the Proceeds of Crime Act and Anti-Money Laundering Act state? In 2019, there was a bill that was to be tabled before the parliament that required all legal practitioners to set their clients' money, the sources of their clients' money. But the bill was, however, rejected. Oh, what does that tell you? I will not say, because I don't have the facts. However, in another case, in Kilifi, Charo versus the Republic, this case, there is a dissenting opinion, and the dissenting opinion brought a lot of comment from the general public, and whether the sexual relations between consenting adults. Remember, in this case, the girl was not an adult, and the boy too was also not an adult. The boy was 17 years and the girl was 13 years, and the parties had sex before attaining the age of maturity, 18 years. Now, one of the judges said that what will happen when the girl behaves in a manner likely to suggest she's an adult? Why are we convicting the man? And remember, in Kenya, defilement cases, you are granted life imprisonment, but the boy being under the age of 18 will not be granted the life imprisonment or the death sentence, because under section 19 of the penal code does not allow for harsh sentences on minors. So that will be another area of discussion. Now, mitigation is part of the trial process under section 215, and such evidence as it sees fit in order to inform itself as the sentence. You see, the judges have to consider mitigation as part of the trial process. However, it's also read together with section 329 of the Evidence Act, and the code in the section says that before passing a sentence, the section 329 of the Criminal Procedure Act, and the court may, before passing sentence, receive such evidence as it thinks fit in order to inform itself as to the proper sentence to be passed. Before a court rushes to make a judgment, it must consider all evidence, and all the evidence, there are circumstantial evidences, and in circumstantial evidence you will find that some factors have to play in part. You see, and those mitigating factors, I'm the one that are saying, we'll deal with them one by one. However, why were they saying, the Francis Muruatetu applicants, why were they saying that it is unconstitutional? If you look at Article 27 of the Constitution, it has provided for equality and freedom from discrimination, since every person before the law is equal and they have the right to equal protection and equal benefit of the law. However, they were saying that convicts sentenced pursuant to Section 204 are not accorded equal treatment to convicts who are sentenced under other sections of the Penal Code that do not mandate a death sentence. They were saying that the other offenses, the judges have to consider other factors, and they wanted now those other factors to be also included in the death penalty sentencing. refusing or denying a convict facing the death sentence to be heard in mitigation, when those facing lesser sentences are allowed to be heard in mitigation, is clearly unjustifiable discrimination and unfair. So that was the basis of the constitutional perspective. And now the judge, the court, in giving out the guidelines with regard to mitigating factors that were applicable, the court started one by one by listing them. One is the age of the offender. Two, being a first offender. In some cases that we'll be also tackling, you'll find that there is a case where the prosecution now is allowed to say that this person is a first-time offender, therefore we should also give him a lesser sentence, you see. Now, another thing is on the age of the offender, you know, the words, it is the law states that sentencing or convicting a minor person, you should not use the word sentencing. Rather, the minor is only in conflict with the law, you see. These are the mitigating factors, and if you delve deeper in the penal code, it says that the age of an offender below the age of 12 years cannot be convicted of any crime, unless there is an exception, unless this person is able to understand the veracity of what he or she is doing. That applies now to age 12 and above, but below the age of 12 years you cannot be prosecuted. Whether the offender also pleaded guilty. You see, there is a case where offenders in Kenya, there are some instances where the prosecution now will say that this person is only a first-time offender, and if in that case that I was saying, where the man said, yes, I killed the man, but I did not intend to, that will still be recorded as a plea of not guilty. See, we will tackle this mitigating factor one by one. Another thing will be the character and record of the offender. How do you relate with people? You are saying you are being defiled, but you work in a bar. Record of the offender. You work maybe in brothels, and you are saying that you are being raped. You see, record of the offender. What are the certificates of good conduct saying about you? Do you have any previous cases before the court? E is the commission of the offense in response to gender-based violence. How do you handle gender-based violence matters? Do you know gender-based violence matters will land you, are likely to give you a harsh penalty in Kenya? Remorsefulness of the offender. Yes, judge, I kill, but I am so sorry. What is the veracity? What is the threshold to determine that remorsefulness? Is the offender lying? Those questions will also answer them. What is the possibility of reform and social readaptation of the offender? How is the society ready to incorporate this man? Sana, this happens when it comes to convicting the minors. You see, the court have to obtain a probation report from the community, and some you find that the community does not want it. How will the court handle the matter where the community are rejecting this boy from entering back to the society? And any other factor that the court considers relevant will also be incorporated. And finally, the court, in reaching out to give its judgment, it gave out the following orders: that the mandatory nature of the death sentence, as provided for under Section 204 of the Penal Code, was hereby declared unconstitutional. The court was so convinced that that section offered a discrimination to the convicts. It was never open to the general public access to justice. And for the avoidance of doubt, the court was so clear to say that this order, that specific order of declaring Section 204 as unconstitutional did not disturb the validity of the death sentence as contemplated under Article 26(3) of the Constitution. Therefore, in another issue that was addressed, how now will the parties be remedied? The matter was hereby remitted to the High Court for hearing on sentence only, on a priority basis and in conformity with the judgment delivered by the Supreme Court. And the Attorney General, the Director of Public Prosecution, and other relevant agencies were tasked to prepare a detailed professional review in the contents of the judgment and orders made with a view to setting up a framework to deal with sentence rehearing cases similar to that of the petitioners. And the Attorney General was granted 12 months to do the same. And also the court directed the Speakers of the National Assembly and the Senate, the Kenya Law Reform Commission, with a signal of the utmost urgency for any necessary amendments to the law, formulation and enactment of statute law to give effect to this judgment on the mandatory nature of the death sentence and parameters of what constitute life imprisonment. In another video, we'll also tackle on Section 8 of the Sexual Offences Act. The Section 8 still retains the mandatory death sentence. Mandatory harsh punishments. You see, what is the veracity of that? Are there any other act of parliament that still grant one harsh sentences for a crime that should not be equivalent to it? Those are the discussions that this channel will be advancing. I'm not teaching about the law. I'm not teaching you what this unit, criminal law unit. No, that's outdated. We have contemporary issues at hand. How will we solve them? Thank you for being a member to this channel. And as I told you, you can comment down in that section. Let me provide you with the link to this website and get in touch with us, and we'll get things started for you. We also have a legal writing, submissions, master project writings, and article writings. And it's a private website, as I told you. And the main aim of, as you can see in the about section, is not monetary, but rather to connect the links between our own laws and in the process advance our jurisprudence. That is what keeps us moving. Now, thank you for your time. Remember, it's only in this channel that where you'll find thoughts and insights around law that will have. Click in the subscription button, both in the website and in the YouTube channel, for you not to miss anymore.